to be improved, because before now, there were no lobbying for person to be made judicial officers. But these days, you sit in your office, you see colleagues coming to lobby you, whether you know any Mr. A, B, C, and D in either Federal Judicial Service Commission or State Judicial Service Commission. So we seem to have thrown the appointment of judicial officers to that pedestal of lobbying, that it has become the survivor of the fittest. So we need to sit down and agree as a nation, who do we appoint as a judicial officer?
With regards to the judiciary, who needs to sit and discuss these issues?
All the stakeholders, the legal practitioners, the public at large, the government that is in power must be serious. We must be serious, because let me tell you, and I've always regarded the legal profession and the judiciary as the light of the nation. And I have said, and I will say it, that is the only profession that has a defined qualification. We are not members of those who can go to be made judges of the High Court, Court of Appeal, or even chief judges of the state or of Federal High Court, or by the definition in section 318 of the Constitution, secondary school or its equivalent. No. The judicial arm of government has a defined qualification. You can't be a judge of a high court except, for instance, you are a legal practitioner called to bar, you have practiced law for not less than 10 years, Court of Appeal 12 years, Supreme Court 15 years. In addition to the other character, fit and proper person, you can't be a senior advocate or just coming from the blue. You must have appeared in all court of superior recourse. I have done contested cases of significant importance to the development and jurisprudential improvement of all your other colleagues. So, if we have that defined qualification, then let us pick the best from ourselves. Now, coming to the legal profession, we now have some, with respect, some people who have no need to be in the legal profession. They are in the legal profession. We must commence a process of weeding out those people from the legal profession, because the legal profession is a profession of trust.
Which body is saddled with this process of weeding out?
Well, you as a lawyer, you have the responsibility under Rule 55 of the Rules of Professional Conduct to report to the Nigerian Bar Association, report to the chairman, Legal Practitioner Disciplinary Committee or Board of Benchers, the Chief Justice of Nigeria, the President of the Court of Appeal, all the presiding justices of the Court of Appeal, or the chairman of the MBA of the various branches across the Federation. Write your petitions, accompanied with an affidavit on oath, if you are sure of it, that this is what the lawyer had done to you or had done that you consider it to be conduct unbecoming of a legal practitioner. And the professional association of the board of lawyers will investigate it, and the NBA will investigate it. And once there is a prima facie case of professional misconduct, you are sent to the Legal Practitioner Disciplinary Committee of the Board of Benchers, of which I have the privilege to be the chief prosecutor of the bar. And we have done quite a number of it, but I'm expecting more, because there are no sacred cows. And we have the rules of professional conduct that is there for lawyers to follow. So I think, and I have advocated, that the process that we have in under jurisdiction, which is self-activating, self-enforcing, should come here. Because you see lawyers waking up today because they don't want the matter to go on, 5 frivolous processes, even joining judges. That service is an act of professional misconduct. Lawyers filing in one matter, filing up to 1, 2, 3, 4, 5, up to 15, 16 cases. That service professional misconduct.
So is it that legal practitioners are their own enemies because you don't name and shame and call out the bad ones amongst you?
Precisely. I think that's you are coming back to also the point I have made, that how serious are we about disciplining ourselves? Have we brought to bear, even in our professional association and our professional calling, the endemic things I call tribalism or sectionalism? Because we seem to be playing with respect, with our disciplinary process. Because if you take on a very big masquerade, some people are afraid. We take on a very big masquerade of the profession, some are afraid. You don't go there. That's an institution. But if you have an institution that is not correct, an institution that is not leading right, because as a senior advocate, you are supposed to be the beacon of hope of the younger ones. You must show example. Because most of this younger generation of lawyers also learn from the conduct of the senior ones. Although some of them have their DNA from birth populated with corruption. So there's nothing you can tell them. But we also need to show by example.
Let's round up with the role of the Nigerian Bar Association. As Chief Prosecutor of the Legal Practitioners Disciplinary Committee, how do you react to the allegations that the NBA does not have the capacity to enforce discipline amongst the senior members of the profession?
No, I think the reasons people have that perception is the current rules we have, where there must be complaint. NBA cannot just wake up now and say, because you are seeing Shola misbehaving, God forbid, then they'll call upon you. There has to be a complaint.
But why can't you just do that without a complaint?
That is the rules that we say we should amend. Okay. In England, for instance, in England and Wales, there are monitoring processes that once the body finds you that your conduct is unbecoming, initiate processes against you. But that's not the case here. In our own case, by the rules in the Legal Practitioner Disciplinary Committee rules 2006, for instance, there has to be a complaint.
But you think that we should tinker with that?
We should tinker with it. We should tinker with it. There should be rough procedure for rough people. So why do we sit down to say, you see that this is completely a thief, you still want police to investigate? Take the person to the body with the evidence you have. So we will need to sit down. We have ailment, and we need to sit down to prescribe the proper procedure and proper remedy and proper drugs to cure the ailment. Otherwise, if you are not careful, in the next 10 years, we may not have the legal profession.